Good morning once again, friends, family. In the previous video, I stated, I made the statement about a document that was created that we served on the Chief Justice of the Supreme Court of Tennessee, Roger Page. We also served the Tennessee Supreme Court Clerk, James M. Havner. You guys heard his name if you've watched the video. And the District Attorney General, Jonathan Skermetti. This was served. This document was created and it was served to these folks. And this is the title of the document is Demand to Dismiss for Lack of Subject Matter in Personam, in rem, and Territorial Jurisdiction. This is our argument. This is a document that was created that is going to be the groundworks for post-conviction if this document isn't addressed. I held up the document itself. This is the exhibits. Okay, that's all the exhibits that were forwarded along with this letter. When we create these documents, we back them up. We're not just telling you our opinion. We're going to back them up with proof. We're going to back them up with case law. Case law is common law. I've said this before in the past, so this is probably going to be a long video, so I'll probably break it down into some parts. If you're interested in this, this is our argument. I don't think I've ever explained the argument in such great detail as I have here, or I'm about to here. So we'll just get started. This was Ronald-James Lyons, beneficiary and sovereign et al. That's all the rest of us, versus the state of Tennessee, or SOT. And it's the corporate state of Tennessee because it's in all caps. Every document, every name in here that's a corporate name will be in all caps, designating that it is in fact corporation. And I'll prove this in here. But it starts out, without prejudice, come now, we, Ronald-James Lyons et al. Gary did one of these with his name, and I don't know about Lee Cromwell because he's pretty much out there. Hereafter, I, me, my, our or us, natural persons, person or persons, and sovereign or sovereigns, okay? Then I placed a footnote in there. This is case law. It's Chisholm versus Georgia. 1 Lawyer's Edition, 440. 2 Dahl, and 419, 417. 472 and 1792, okay? And this is a quote from the case. At the Revolution, the sovereignty developed on the people, and they are truly the sovereigns of the country. But they are sovereigns without subjects, and having none to govern but themselves. The citizens of America, not the United States, are equal as fellow citizens, as a joint tenant in the sovereignty. Now, it's old, 1792, right at the beginning of the country, but that's straight up. This is what this is. You are sovereign. If someone tells you you're not, tell them go hell. Tell them go to hell. Because you are. But anyway, and Ronald-James Lyons, beneficiary of the public vessel, public vessel, one owned and used by a nation or government for public service, whether in its navy, in revenue service, or otherwise. That's Black's Law Dictionary. I'm trying not to get into too many of these footnotes, but some of them are crazy fantastic. With which are sestike trusts, I, as a state press gang conscriptee, when you're in the prison system, you've been conscripted into the military. It's kind of like being drafted and not being able to do anything about it. So you'll hear the acronym SPG in this document. That's what it stands for. In propria persona, appearing specially, not generally or voluntarily, in writing as sole beneficiary of both the Social Security Sestike Trust. In this instance, this is Ronald James Lyons, all caps. And then it's trust number, which would be the SSN. And it's final prison trust, Lyons Ronald, because in prison they go by your last name and your first, all caps, with the trust number 005935583. That's Ron's trust prison number. When you go to prison, what they do is they attach your prison number to the Social Security number. That's why they count you twice a day. That's an inventory of a financial account. It's an audit. As you know, I cannot make a decision for either the trust because I am not the trustee. I am respectfully demanding that this Supreme Tribunal order my release per my demand to dismiss for lack of subject matter in propria, in personam, in rem, and in territory jurisdiction in accordance with IAW Tennessee Code 4014-101. The Tennessee State Constitution, hereinafter be referred to as P1, Article 1, Section 1 through 36. It's the Tennessee Constitution. And the Constitution for the United States of America with Amendments 1 through 10 are your Bill of Rights. Okay? Now, when you hear in personam, this is Hudson versus Genesis Healthcare, 2022 U.S. District. This is from LexisNexis. Personal jurisdiction may only be established by the act of the defendant. So for them to have personal jurisdiction, the defendant or you has to give it. That's Walden versus Flora, and that is a 2014 ruling. The relationship must arise, this is 2022 U.S. District, Lexis 13, out of contacts that the defendant himself created with the forum state. Quoting Burger King 471 U.S. at 475. And that's Hudson versus Genesis Healthcare, Inc. So they don't have it. They don't have it till you give it to them. I've said this before in the past. So I'm going to talk about a couple other things here. And I'll read this. We hereby challenge jurisdiction. That's is footnoted with 7. It was said to be well settled that the jurisdiction of any court exercising authority over a subject may be inquired into in every other court when the proceeding in the former are relied upon and brought before the latter by the party claiming the benefit of such proceedings, and that the rule prevails whether the decree of judgment has been given in a court of admiralty, chancellery, ecclesiastical court, or court of common law, or whether the point ruled has arisen under the law of nations, the practice in chancellery, or municipal laws of states. You guys will be familiar how I blasted the municipal in the very first video. Completion of this record. Wait a minute. Did I do that right? Okay, no, wait a minute. Let me back this up. We hereby challenge jurisdiction and declare that this tribunal has no jurisdiction over me, us, the sovereign, nor me, us, the sole beneficiary of our respective Social Security Cestacate trusts. We, therefore challenge any and all alleged jurisdictional claims to be entered on the record, and a copy of such record sent to me evidencing completion of this record. But through us, you do have authority, and more specifically the Chief Justice, and that was Roger Page, of the Supreme Court of Tennessee, all caps. Remember that the Chief Justice is working as the CEO of the corporation known as the Supreme Court of Tennessee. And it goes on to say, a corporate entity and subsidiary of the corporate state of Tennessee, in all caps. Here it's acronymed as SOT. I thought that was kind of funny because SOT has to do with somebody who drinks a lot. As the highest authority over the trial tribunal and their administrators. Like I said in one of the last videos, the Chief Justice is over all the other trial tribunals, because they're tribunals, they're military tribunals. It is therefore an offense which is not to be visited on the sovereign or his property. Reprisal cannot lawfully be made until application of him for redress has been made. Courts of justice cannot interfere in such a case because the sovereign cannot condescend to appear in them. Now, that's a quote from the Santissimus Trinidad, 5 Lawyers Edition, 454, 7 Wheat, 283. In support of my or our declaration, we feel are entitled to the relief demanded herein. We hereby state, after firstly being duly sworn according to common law, depose. Then there's some bullets. 1. My name is, in this instance, Ronald-James Lyons, a human man, a natural person, and not a fiction of law, governed as such under your rules or statutes of commerce or the law of merchants, but a sovereign, okay, and beneficiary at all. So sovereign, here's a footnote. A sovereign is exempt from suit, not because of any formal conception or obsolete theory, but on the logical and practical grounds that there can be no legal right as against the authority to make the law on which the right depends. That's Kawanadaka. I'll spell it. I probably hacked this up really bad. Kawananakoa versus Polyblank. 51 Lawyers Edition, 834, 205, U.S. 349. And then it reverts back to footnote 2. As addressed supra, and I declare such an administrator, Cheryl A. Blackburn, that's in all caps, she's doing business as her trust, court-martial hearing from the onset, and these facts were unchallenged by Cheryl, the clerk of the tribunal, or the prosecutor. Moreover, I began each hearing declaring my reservation of rights by verbalizing the words, without prejudice. At each hearing, I was forced to attend. We were neither actively nor inactively in the United States military, nor in the state militia. Yet we were kidnapped on February 15th, 2017, by an agent of the Tennessee Bureau of Investigations, or TBI, in all caps. Remember, it's a corporation. And a Federal Bureau of Investigations, FBI, which is also a federal corporation. Agent and other department statute enforcement officers and agents acting under authority of the federal and state yellow fringed flag. And I've read this before. This is, you display a military flag as your jurisdiction. See Title IV, United States Code Services, Lawyers Edition, subsection 1, interpretive notes and decisions. 1, generally, authority of president. Placing a fringe on the national flag are within the discretion of the president as commander-in-chief of the Army and the Navy. 1925, 34, Attorney General, or opinion of the Attorney General, 483. In addition, pursuant to Title IV, United States Code, Chapters 1, 2, and 3, Executive Order Number 10834, August 21st, 1959, 24 FR 6865, a military flag is a flag that resembles the regular flag of the United States, except that it has a yellow fringe bordered on 3 sides. The President of the United States designates this deviation from the regular flag by executive order and in his capacity as Commander-in-Chief of the Armed Forces. Moreover, that Congress willfully and knowingly overstepped its power, to wit, in 1845, Congress passed an act saying Admiralty law could come on the land. The bill may be traced in Congressional Globe, 28th Congress, 2nd Session, 43, 320, 328, 337, 345, 1844 and 45. No opposition to the act is reported. Congress held a committee on the subject in 1850, and they said the committee also alluded to the great force. The great constitutional question as to the power of Congress to extend maritime jurisdiction beyond ground occupied by it at the adoption of the Constitution. That's H.R. Rep. number 72, 31st Congress, 1st Session, 2 of 1850. Okay, there's a little bit more to that, but I don't want to get into it because it's going to absorb a crazy amount of time. So anyway, there's your argument for it being a military tribunal. But that's not really that important. It really isn't, because we didn't grant their jurisdiction anyway. Let's see. Here's number 6. I just went through here and picked out things that I thought needed to be stressed the most, which is quite a bit here. 6. The final SSC, or Social Security Certificate Trust, prison trust number, which I am the lawful and sole beneficiary of, 00593583, was assigned to me by the Gestapo, evidenced by the ID that I'm required to display, where the language inmate number 00593583, Lyons Ronald, in all caps, is prominent and has my wet ink signature declaring that I am the beneficiary, as well as without prejudice, with my picture on the reverse side showing who the beneficiary is, giving witness that the inmate, in all caps, is the trust, and I, the human sovereign beneficiary, am being held as ransom against both the Social Security Certificate Trust and the Finalo Prison Trust. They allowed Ron to sign his own badge, and they started doing that after I charged the prison warden at Bledsoe with 2 counts of forgery, where they were letting the prison guards sign the signatures on our signature line. That's a signature line on that badge. It says signature underneath it, which means if you sign it and it's not you, then you committed forgery. And here I am charging the prison warden with hundreds of forgeries every time a new bus comes in. They're getting away with it. But I did that. Once I filed charges against him for forgery, they started letting inmates sign their own badges. Ron signed his without prejudice and beneficiary and all that. So they agreed. Remember, acquiescence is agreement by silence. If somebody says something to you, you'd better, and it's not true, you better say something back. That's also in this document too, here in a couple occasions. That we was or were taken on February 15, 2017 by agents of the TBI and FBI, and yet to this day I have not been presented with any warrant or capias with my name affixed. However, agents at the time of the so-called arrest may have had paperwork with them of the Social Security Certificate Trust, RJL, or Ronald, it's an acronym for Ronald James Lyons, affixing the law. Annette UCC1 financing statements filed with the Secretary of State on 10/16/16. This act evidences the fact that I, the natural person, was kidnapped, because you cannot arrest nor kidnap a fiction of law. Furthermore, there were 9 other natural persons kidnapped at the same time as I was, that those responsible should be held accountable. Okay? We bringing up all this stuff on them. Be aware. I don't expect this to really go anywhere, other than the fact that we're going to send this to you certified mail return receipt. You just accepted a contract via the postal roll. That's also in here. Let's see here. That however the trust had before this Supreme Tribunal, the court-martial jury trial, charges shown as Tennessee Code annotated 39-17-117, false filing of liens, and 3914-114 forgery. If you guys want to look up what it is that they charged our trust with. Hence, the trust was prosecuted in a court-martial jury trial, and the sovereigns and beneficiaries were prosecuted in the bench trial under statute Tennessee Code annotated 39-3-906. And I'll get into that. That's the one that I found that they had on the prison record that was repealed in 89. Now, if you repeal a code in 89, how is it that we were at the bench trial, we were charged with something that hadn't existed in 30 years? 39, there's a typo, 39-17-117 and 39-14-114, of which I have been unlawfully attached, to the trust as a PGC and held for ransom until the trust pays. Thus, at no time did any of us have a constitutionally secured trial by jury. You've heard me say this a couple of times in this document, jury trial. A jury trial is not a trial by jury. So if, we'll take this to a jury trial, you're not getting a trial by jury, you're getting a jury trial. It's simple English grammar. Some of y'all will know what I'm talking about once I mention that. According to the opinion, this is the Supreme Court opinion. According to the opinion, page 2, paragraph 1, factual and procedural history. Bivens et al. Is declaring that we were charged with, see Tennessee Code annotated 39-14 or 39-14-105 A6 2018 supplement 2020. Well, check it out. This thing that he's saying that we were charged with didn't even happen until 2018. A lot of you are going to get that right off the bat. What is that? What is that when they do that? You know, if we committed a crime in 2016 and you arrested us in 2017, then all of a sudden this code is put on you, 39-14-105 A6. What is that? 39-14-114 and 39-17-117. Showing ex post facto status. This Supreme Court judge is saying that we're charged with a law that didn't even, for one, hadn't existed since 89, and the other one hadn't existed till, 4 years after or 3 years after the alleged offense. Yeah. This is what they do. We, on the other hand, are being imprisoned under 39-17-117 fraud, or 39-14-117 fraud, insolvency, merchant's lien law, and 39-14-114 forgery of greater than 250,000 or more. And Bivens et al., that Bivens is the one that wrote the opinion, included all 102 UCC1s in his first charge and then declared them as fact. This is a fact. Further, the jurisdiction of the trial tribunal was challenged multiple times by multiple sovereigns prior to the trial, and the trial tribunal neither acknowledged nor challenged nor validated their jurisdiction on the record. When you go in there and say, look, I'm challenging the jurisdiction, if they don't say anything at all, what do? They just acquiesce to it. That's going on a half hour, so I'm going to cut this one and I'll start back with another one. I'm trying to break this up so you guys ain't overwhelmed with the document. I'm just page 6 of 33, you all. All right, this may be broken up into quite a few parts, but right back at you.